and I'm going to turn over to Professor Koo.
If the advice is.
All right, thank you. Now I'm going to assume both the kind of moderator as well as participant role for the remainder of the hour. And what I'd like to do is just let you know that throughout the process, I would like to field questions from the audience in addition to debating among ourselves, because we'd like to assume that the initial kind of we bored you to death by the talking to you part is now over, and that this will be an active process in which everyone's engaged in the discussion, since ultimately we are all engaged in this discussion. So I'd like to start. Is there a question from the audience first? Yes.
My name's Marta. I'm a student here, and I don't really know very much about the licensing agreements between broadcast radio stations and the ASCP and BMI. But I was wondering if Mr. Garfield and Mr. Shultz, you could tell us a little bit more about the differences or what goes on that allows people to opt out of broadcasting licenses that would not be feasible in a digital realm, or what maybe would be better about tracking an actual, getting a more realistic count than just a sampling of 2 days a year on the radio station that would be more beneficial in a digital realm than the current structure with radio broadcasting.
My answer is probably pretty simple, which is I don't think there's any problems with the transition. I mean, yeah, our songwriters right now can opt out of ASCAP or BMI, and those agencies, those societies don't represent everybody. They represent almost everybody because it makes sense to sign up.
They can opt out of ASCAP or BMI, but they can't opt out of the mechanical license.
But they can't, exactly, which I think is, I mean, it's a little bit off of your question, but it is a good point. We're proposing something like ASCAP and BMI, not something like a mechanical license. So there actually is choice. In our proposal, you wouldn't have to sign up as a copyright owner or an artist with any society if you don't want to. You can take your chances any way you want, but this we think is a better option to have, and it will probably cover most people. In terms of sampling, I do think you'll have, I mean, this is a question better left to the technologists who work in this every day. It's not my role. I'm a lawyer. I'm not a technologist. But I do think that, yeah, you will get better sampling rates than you do for TV and broadcast radio. What we're saying is, of the solutions out there, if it's good enough for broadcast radio and it's good enough for the billions of dollars of advertising spent on TV revenue, it's going to be good enough for music file sharing, and it will probably be better. It'll probably allow a lot more smaller independent artists to be picked up on the radar screen, because you can do like Mark does and monitor the networks. I mean, he sees all those file names going up. A lot of them are 50 cents and things like that, but there might be small artists too that are caught up in the list, and therefore those artists will also get compensated.
Well, Dean, what's the response to that? I mean, especially in light of the fact that mechanical licensing really allows the recording industry to do what it's doing. Why is it wrong for the next step into a new potential distribution technology?
I think it's unnecessary. That's why I think it's wrong. You can have the solution of having public domain works available without changing the current structure of copyright. I think you can have those services peer-to-peer. The challenge is not, do you promote public domain works or do you allow copyright as it's currently constructed to exist? I think the way that we set up the dynamic as a division between the promotion of technology and the permitting technology to continue to develop, or copyright, is a false dichotomy. You can have technology continue to develop and still have copyright as it exists today. I think on these systems you can identify files and filter out copyrighted content. You would allow technology to continue to develop. You would have P2P file sharing services. You just wouldn't trade copyrighted content.
You know, Dean, as you know, I'm not a fan of compulsory licenses or levies. I guess where I get a little bit confused is, why aren't you lobbying for the end of the mechanical license? I mean, if I write a song and it's publicly performed once, any one of your members can take that song and can use it. I have no control over that.
You can't opt out.
I can't opt out. I mean, why is that system, unless the music industry has changed its position, why is that form of compulsory license good, but others aren't? I mean, I don't like any of them, but I'm just curious.
I think it's not a question of whether it's good or bad. It's what exists today, and the question is it necessary to follow that paradigm as a solution for today's problems? And I don't think that it is.
Well, the real question isn't is it necessary, but is it beneficial? Right? What's the cost of adopting the private property model? Right? It's the same cost that the recording industry feared with the copyright with regard to sheet music publishers, which is that some sheet music publishers will not license the work to various recording artists, or will license them at rates that they weren't happy to pay, and Congress stepped in. The idea being that a sheet music publisher, as opposed to the songwriter, shouldn't be able to control what happens when we're distributing music, not as music that people play in the living room, but as music that people get to listen to as a recorded form of entertainment.
Yeah, but there was I think there was a legitimate concern of stifling a form of technology, which I don't think exists here.
Any other questions? Another question right now?
All these bright students and no questions.
Yes.
Professor, I have a question about the Charles River Bridge analogy you were drawing. It
Sure.
seems like, without having a lot of knowledge about the area, that the answers to the bridges, to the toll roads, was almost complete public control of those technologies. The building of bridges, building of roads, largely, not 100%, but largely public investment into that stuff.
Well, that's actually factually inaccurate.
Oh, yeah?
Right? It is today, right? When we think of the Big Dig in Boston, right? So if you wanted to find pictures of the Charles River Bridge, what you're going to find is this new cable suspension bridge as part of the Big Dig, right? That is mostly publicly funded. At the time, and we're talking about the 19th century here, right? Pre-commercial and industrial revolution, these projects were largely privately financed. The idea was the government gave you an exclusive franchise to operate a ferry, to operate a stagecoach, to build a bridge, to operate a canal, and you did that, and you charged people tolls, and that's how you kind of recouped your investment. Now, the interesting thing happens that after the Charles River Bridge case is partly the legislature's wised up. They realized that they didn't have to give these extraordinarily long periods of exclusive rights. So to the extent they wanted one, and they wanted to guarantee that there wouldn't be competition, they said it specifically, and then they changed the model in which they said, okay, well, you can recoup your costs and then a small amount of profit, but we're not going to give you 100 years to exploit that privilege. And part of the problem in that case was the bridge investors were arguing that their rights dated all the way back to the common law and feudal times from the original royal grant of a charter to a ferry operated by Harvard College. And so ultimately, their argument has been one that's been replicated throughout copyright law, which is that the idea of control and property in the work is perpetual and a permanent right. What do you think? Is the bridge analogy just a bad professorial academic?
I was thinking that when you were speaking, but no, I'm kidding. The question that it raised for me was, how does freely available promote the progress of science or any of the other concepts in Article 1, Section 8, more than exclusive rights? And I couldn't find that answer.
Well, a couple of things, right? I mean, to the extent that artists are now, to use the expression from Jane Ginsburg, no longer in the thrall of record labels and distributors, it means that more artists will reach the public and in larger numbers. That you add that to the fact that we're not talking about just music here. We're talking about computers, we're talking about consumer electronics, we're talking about internet service and telecommunications. All of these industries are implicated in the copyright question. And to the extent that we try to preserve an exclusive rights regime, we are effectively dictating how all of those other industries, not only what artists will do, but all these other industries will do.
I think rather than dictating, we're making a guess as to what motivates people.
Well, I think you need to be careful. I mean, none of these examples are clean and clear, and we get into the public transportation stuff, which is largely railroads and airlines and ships were funded some way by the government. So there's some truth to that. I agree the roads at those times weren't, but the issue is difficult because one of the reasons that I think kids particularly felt that it wasn't a bad thing to do file sharing. And again, I think trading people's copyright material isn't right, but looking at it from teenagers, and again, I've spoken to a lot of high school students on this, they start in with the mantra of, look, they've been giving away music, not only giving away music on the radio station, they've been paying the radio station to play music, to force our tastes in a given direction. I mean, these kids are very sophisticated. And that problem is going to get worse with digital radio because that stuff is going to be of better quality and unprotected. I don't know what that's going to mean for our future as well. Not that I want to shut down digital radio, because I think the concept is a good one. So you have this issue of, again, the new artists, and a number of them have revitalized their career on the internet by giving away their music and touring, and that's a fair model.
Right.
Again, the question in my mind is how, with all the participants, and I don't have easy answers, how do we take this energy that is, a lot of people want something for nothing, but I think that if you were to be able to forget all the existing laws and licenses for a moment, which you can't, of course, but for a moment, and think of this as a business, I personally think Bertelsmann was right. I think that there was an opportunity to take the Napster energy and turn it into a for-pay service. I think they had the broom in their hands at the time. And again, the laws made it very difficult to do, though.
I don't think that opportunity has been lost. I think within a matter of years, you'll see peer-to-peer systems that are legitimate, that have filtering, that are in fact licensed by the record companies. I think the concept of mass distribution, where individuals who partake in these peer-to-peer services are rewarded for sharing and marketing music, will be real in a short period of time. I think the technology to do it is there, and the will to do it is there.
I think the only hang-up with that, and again, it is one of sort of licensing and is the Michael Jacksons of the world. It's
Exactly.
3%. I mean, this isn't a 80-20 rule. This is a 97-3%. 3% of the artists, in terms of CD sales, represent the vast, vast majority of sales, a huge amount of sales, and many of those, because of their power with your members, are just licensing to you their performance rights. You don't own them. And having a filter system that filters out that 3% is not going to be attractive to people. You're not going to draw in the audience. So it's a tough challenge.
Yeah, it certainly will. I mean, you won't have the Beatles.
Yeah, and so people will continue to have that desire. And you need to have I think to be popular, you need to have a system which has as much available. I mean, I don't know how many titles have been issued since we had CDs. Or at least individual songs, millions.
Right.
So it's a difficult conundrum because you have to have the specific gravity to pull people in.
What's the case that keeping the current distributors around, is there a case that that's good? Because in your example was you pull out the middleman, and what I sense is the middleman doesn't want to be pulled out, and they're going to kick and scream to the end. But the question in my mind is, without the middleman, what would it look like? Not that everything's free and everybody gets screwed, but if you took the middleman out, what has happened to the big picture, and what is the public loss if the middleman's gone?
Well, from the representative of one of the middlemen, or
The
part of
man.
it, all right?
The man.
DA.
What's that, right? I mean, if I'm an artist, why do I want to keep the RIAA and its members around, to the extent that we could create a model in which the artist can go it alone?
It's your choice. I mean, some people believe that the lessons that the recording industry and the record companies have learned over the years in marketing and creating some excitement around an artist is valuable. There are others who do not. And I think that's the power of these file sharing systems. I mean, we continue to say it, but people really don't believe it. The challenge for us is not technology, it's not P2P systems. You can set all sorts of business rules around that technology. The challenge for us is copyright and educating people about copyright and enforcing ours.
Well, the difference is that Leo Burnett, for example, a major advertiser, does a lot of marketing for all sorts of clients. They don't have copyright. They don't have control over the means of distribution. So they're not able to tell their clients, all right, well, you're going to give us 90% of your revenue, and then we'll do your ad. I mean, why should we keep distributors to the extent that there's this imbalance?
Go ahead, Jim.
Can I answer that? Because I'm really having a tough time, because I keep agreeing with Dean, which just annoys the heck out of me. But because I want to have a fight, and we don't seem to be able to do that. Yeah, But in any event, now I'm going to put on a different hat and reveal my age. I used to be a roadie for bands. I worked with Bill Hanley, who was the sound man for the Beatles. I did the last Beatles concert. I had an intimate contact with the music business a long time ago in a different galaxy. And I believe that at least back then, the middleman had a much more valuable role than just creating the excitement around that. That was the last thing that they did back then. What they did was to find talent and develop them. And just because the medium might be peer-to-peer as opposed to concerts, but still be concerts, there's a really valuable role for the middle person in this. And it isn't just cracking down and running trucks with plastic on it. It is about the talent. And there's that wonderful Tom Hanks movie. What was the name of it? The One Hit Wonders? Oh, God, a great movie. And say again? That Thing You Do. I really recommend you look at it because that gives you a view back in the days I was involved of what the middle person, it wasn't just about making the record, it was about developing the talent. And I think if you look at the internet, and what is it, nobody knows you're a dog on the internet? I mean, I think that's going to be a more valuable role because the noise level will be huge. The question is whether the labels are the people who'll be able to do that or not.
Yeah, and I think
Whether or not you need exclusive
Right,
rights
that's right.
to do that.
Yeah, well, I don't think, it seems to me that we're conflating exclusive rights with the distributor. You can have exclusive rights and anyone can be the distributor. The distributor could be me or you. It just so happens that some people come together around record companies as the distributor, but I don't think that challenges the need for an exclusive right. I agree wholeheartedly on the need for artists in development, particularly with these new file sharing services. I mean, there's so many different bands that are available, that are out there. You will need some entity that will develop and find particular artists and make them more known than they would be by just putting up a sign in a jungle.
Jason?
Well, should I address that or should I?
No, you
Should defer to the judge.
So I do have a bone to pick with something you said, and that is that it seems to me that the position that you're taking is that you don't have a problem with the peer-to-peer technology, you just want filtering. You just want to be able to have filtering as part of the technology so that people can opt in or out with their works. I would take the position that that is an impossible reality. Because basically, I mean, given sort of what Jim was talking about people wanting everything, if peer-to-peer technology is legal, right? If it is legal to create a tool that allows a peer-to-peer network to form, if that stands to be the law, and some companies put in filtering, there will be an option for internet users. You can get a peer-to-peer client, that gives you everything, or you can get a peer-to-peer client that gives you only some of what you may want to look at and listen to. And I think it'll drive people to the app that gives you everything. And so I think ultimately what your road would lead down would be to try and mandate that every single peer-to-peer application have filtering in it, because if not, my question to you is what would keep people from going to applications that don't have filtering?
I think it would be listening to consumers, which is the record companies would be forced to actually license the P2P services that did have filtering. So you wouldn't have everything. You may not have the Beatles, but you would have everything else. And the people who wanted to ensure that when you clicked on Britney Spears, you were not getting pornography, you were actually getting a song, would gravitate to that. Right? Well, maybe some mild form of pornography.
Be nice, Your Honor, be nice.
Your Honor?
I don't want to make them fight.
Uh-oh.
I spend a lot of time in the third world, and I can sell intellectual property there on the idea that it's a short-term bargain. Everything that was invented before 1984 is now free to you. And how magnificent it is that
For patent law.
this generation pays a little bit now to pass on this magnificent gift of new technology to the next generation. Isn't there a problem with copyright law in that the limited term and the freedom involved in the bargain seems to be disappearing as the extensions of copyright terms get prolonged?
Dean's looking.
That part of this debate, in the sense that you need to restore the promise of free creative material in a limited term which we seem to have lost with some of our recent enactments.
Well, it's interesting because a higher authority than your court
See, I wasn't going to say that.
says that Congress has the right to be stupid. But as some, yeah. But as someone who filed a brief, an amicus brief for Intel, it happened to be, on the Eldridge case, I think they went too far. But the problem is, constitutionally, the Supreme Court spoken, but from that extension, the Congress did in the Sonny Bono
Right.
Act, because
Retroactively.
right. Well, retroactively was really a problem for me because if what I'm sorry.
You wouldn't say they don't have the authority.
Unfortunately, what we tried to do is get the Supreme Court to say, okay, but no more, and they didn't even do that. They just said Congress can be as stupid as they like. The Constitution doesn't define what limited, for limited time is. But I think you're right, that I think that the bargain becomes very attenuated when what you're doing is protecting Walt Disney's Mickey Mouse character. Because how that how that promotes artists to create stuff by retroactively applying makes no sense. It's not logical. And I think at some point the bargain becomes too attenuated when you can't get stuff in the public domain. There's an interesting debate between a fellow by the name of DeLong and Professor Lessig, who many of you know. And actually, and DeLong is on the right-hand side with PFF, not EFF. And Lessig's accused of being on the left-hand side, of saying this bargain's a problem for our culture because things are so old. And this is some of the problem the record industry has. That's why they like the mechanical license. How do we find the author even? And works will disappear. The argument on the other side is, well, we're going to invest money in keeping it alive. So they came up with a really interesting proposal that I haven't thought about a lot because I just read about it, but I thought it was fascinating, which is it's a 50-year term, and then you have to pay $1 to renew it. And if you don't renew it, it goes into the public domain. That gets us a little back towards the bargain. I'm not saying the time is exactly right, and I haven't thought about the time period, but I think we have a problem now. I agree with you. I think the term is too long, and we need to restore that balance to say, look, we've got a bargain. We're going to give people some set of exclusive rights for a limited time, so we encourage people to do that. There's another movie, by the way, you all ought to see. I'm terrible about movie names, but about that boy. This is probably one of the reasons not to have a very long copyright term.
About a boy.
About a boy, right. Right.
Santa Claus chicken.
Yeah, right, where he plays a wastrel because his dad wrote the famous Christmas song, and he keeps getting royalties long after his father's passed away. So I think there is a problem.
Professor Lang?
I want to raise a question that actually, in my mind at least, does derive from the things that have been said, but it brings us back to the point that surfaced and then submerged and surfaced again in the course of your 5 initial presentations, and that I would love to hear the panel speak to more directly and in a more lingering way. I think all of you, except maybe Jason, and possibly you, Raymond, suppose that peer-to-peer file sharing, particularly in the uploading end of it, but I think Dean would say, and probably Jim would agree, but even in the downloading end of peer-to-peer file sharing, there's something that violates copyright law and is therefore on that ground wrong. And I put it to you, I think I'm agreeing with what you and Carrie think, that virtually all students know that. I mean, she may have written to you to say that she didn't, but I believe she lied. She lied for understandable reasons, but nevertheless, I think she probably lied. She didn't know that it was illegal, and I think most students do. It does not follow, however, as Mark suggested, that they will learn or that they think or that they can be made to suppose that it is wrong, because those are not the same things at all. I put it to you that the problem is that you're in the same position that Mahatma Gandhi was famously said to have been in when he observed, "There go my people and I must follow them, for I am their leader." The problem is that when you lose control of the society, when society doesn't believe what the laws say, then no matter how you may tinker about the edges, no matter how draconian the solutions may be, the penalties, the sort of Pinkerton-like inquiries by companies like Marx, in the end,
It's a way with words.
the law changes because the society has already changed. So I want to put it to you, drawing on yet another metaphor, but this one a much older one. As the Old Testament observes, you must train up a child in the way that he should go, because when he is a man, he will not turn from it. And one problem is that that's not happened. The problem begins, it seems to me, I'm offering a set of observations, but they are not meant to be a diatribe. They're actually meant to gain some comment. The problem is that the recording industry has not been protected by copyright law for very long. Actually, recordings have only been protected since 1971, and even then, technically, it wasn't until 1972 that the law became effective. Your business model began as a model that didn't depend upon copyright protection because you didn't have any. Now, 34 years later, you have some, but it never really has worked very well because in the very set of hearings in which you got that 1971 sound recording amendment, I keep speaking as if I'm only speaking to Dean. This is entre nous, this is we as they. In those very hearings, a congressman asked one of the recording industry proponents of the legislation, now let me ask, he said, does this law mean that my son, when he uses his tape recorder to tape music from his sister's cousin's boyfriend, would he be in violation of the law? And of course, as anyone would say, in the circumstance, oh no, Congressman, not at all. Why, no, there'd be no violation there. Train up a child in the way that he should go, and when he is 30 years later, it seems to me not surprising that people who are engaged in most of the peer-to-peer file sharing don't actually think it's wrong. They may think it's illegal. They may engage in some fear, uncertainty, and doubt, but even the fear, uncertainty, and doubt will not lead them to think it's wrong. What it will lead them to think is that you are being unfair, that you are being overbearing, and that they are confronted by a challenge. Now, in my own view, observing these things over as many years as this controversy has been abroad, I can't help thinking that you have no alternative but to rethink copyright and to rethink your business model, and that you're just whistling past the graveyard. If you imagine seriously that you can convert the nation by visiting third graders in their dens and tell them that they should really understand copyright the way you do, because they're not going to, I believe. And I believe more than that most people eventually will come to the point at which, is it illegal? They'll say yes. But to the question whether it is wrong, they will say no. And I could give you, of course, dozens, scores of examples from American history in which that phenomenon has resulted in enormous sea changes in the law and in the way we think. But I won't, because you can understand them as well as I. Think just about one example. Well, no, don't think about it. Let me stop and see whether this strikes any chord. I'd really be interested in hearing your responses to this.
Dean, do you want to lead us off?
It was tossed to me, I can see.
Well, I'm sure we all have comments. I'm sure.
Yeah.
You can start, Jim.
Oh, I want me to start? Well, the first recording is actually there's an interesting technicality where recording that music off the internet might not be a copyright violation if you are using a device under the Audio Home Recording Act, because there's an exemption, section 1008, which I don't think anybody has any of those devices, but if you did, it wouldn't be a copyright violation. But yeah, well, that's a different approach, because that's got to be an equitable defense. But I agree with you to a large extent, and this has been my plea. And the problem is making all the pieces come together. And this was our plea in 1998 when we saw the handwriting on the wall: was you got to get into the market. And again, I think that the problem with training people is that we didn't get in early enough, and quick enough, and soon enough, and given people a good, desirable alternative. Because most people, I remember starkly when they had some Napster hearings on the Hill, and it was, oh God, my brain is really going today, but Senator Schumer from New York was up there going, my daughter, who's 16, for the first time came running into my bedroom and uttered a political statement for the first time in her life. You've got to pass a constitutional amendment to make Napster legal. and she then said to her dad, name a dozen of the songs you loved when you were a kid. And he said she came back like a half hour later with a CD with all these songs. And there was one I've been trying to find in the record stores, and I couldn't find Don't Walk Away Today. And then I can't forget which guy from the Eagles bent over and said, with all due respect, Congressman, it's Walk Away, Renee. He said, no, I had a girlfriend in high school named Renee, and I didn't want her to walk away. But, the point is, to me, it's right, wrong, the law. I mean, those are all interesting things, and I get paid to debate those. But I think the issue is ultimately a business issue. if we can, and it's interesting to see EFF, whether you agree with the model or not, Dean. I mean, they're suggesting business alternative, getting out there and getting it to the people. And that to me is what convinces people. I don't believe there are 60 to 100 million felons out there. I think people want to do the right thing. Yes, people love free, but I think you can give them better than free. DVD, for example, is badly broken. DECSS, any place on the website you can get it. And you see lots of movies there on Mark's chart. Yet DVDs last year set an incredible record, $16.1 billion in sales and rentals, almost double the box office of the previous year. Plus, a little unknown thing, $1 billion worth of television. Anybody with half a brain can record television, yet people go and do that. Music videos on DVD up 150% last year. So I think it's a question of getting the product out there. Now, of course, there's constraints on the web. That's why people aren't. If you could download a DVD like this, I think those numbers might be different. But the issue is trying to keep ahead of the market, and here it's very difficult. Oh, what did I do, Your Honor?
No, the professor argued by metaphor. You need to respond by metaphor.
Let's see.
That was reality.
The argument is that is easily rebutted by recognizing that all law has been an educational process, and all law has begun with a Wild West mentality, and in search for efficiency, we've found some imposed legal order. The Norsemen of Norway and Sweden invaded the coast of France and would rape and pillage, kill the men, carry away the women. By the time the king's forces would arrive, they'd already be on their ships and gone. Stealing, killing. What was the response? Do you remember?
I was busy doing other things.
Reading Thoreau.
You got to stick with the method. The first king of France induces Roland, the king of Norway, to settle in Normandy, and promises him he can have that land in response for living an orderly life. By the way, Roland's grandson is William the Conqueror, who becomes the king of England. What happens? The Wild West mentality that starts is reversed by the need for efficiency and order to some kind of a legal regime. I think that education and the role of the law through enforcement to bring that about is exactly what we're talking about here. The professor's metaphors, by the way, were self-contradictory. He started out by saying everybody knows that
You know how to
it's
start an
illegal
argument.
and stealing to do this, and yet in the end he said, but we've got to allow it anyway. Of course not. We've got to bring order and find the efficient order. We've got to induce Roland to settle in Normandy and become, through his grandson, King of England, and bring about the greatest reform in the laws of mankind is known through the Magna Carta a few years ago.
Yeah, but we have to, Your Honor, with all due respect, we have to be careful using another simile, not to be what Anatole France says, pass laws that forbid both the rich and the poor from sleeping under the bridges.
Oh, absolutely. You've got to find the efficient model, and that's where we head. But I don't think you further that by saying, well, we've got a status quo. We've already induced our young to become thieves, so now we must tolerate that regime. Of course not.
Yeah.
You've got to induce Roland to settle in Normandy.
Well, let me flip that on you a bit before.
Can we just cut out the panel and the judge?
The judge,
If you
the
will.
professor. But the question is, what is the efficient answer, right? I mean, we would all agree.
That's back where we should be.
Right.
That's back where we should be.
And that's what the focus of this debate. The problem is the rhetoric often says, well, the efficient answer is let private property and the private market work it out. And that's the typical economist response. But that fails to recognize that copyright in all its forms is illegal intervention into the market to produce certain efficient results, or results that we hope approximate efficiency. And when you have those fundamental conditions and assumptions change, what do? And so to say that have William the Conqueror come into England is not necessarily clear, because maybe what you want is not the kind of Frankenstein version of Napster, but Sean Fanning's original version of Napster, and say that was the efficient market solution. And to the extent that businesses that were built on the concept that we have to distribute and only distribute, right, provide no other value to the creative process, well, frankly, they should go the way of the horse and buggy when the automobile comes along. And so we have to be careful what interests we're talking about and what the assumptions are that we're dealing with.
Oh, but they all sued Henry Ford's customers.
That's right.
I
Remember?
just want to add a couple of things. I mean, I don't disagree that we're looking for an efficient solution here, but I do think that, I mean, I'm not as familiar with this historical example as you are, obviously, but it seems to me that there are a lot of forces involved in that solution about internal political forces, control over your own people. I mean, if the rulers of the armies can't control their armies, then that solution doesn't necessarily work. And I think one of the things that we have to look at here is social norms, because that is a factor. Are you fighting against them or are you going with them? It doesn't necessarily change what you think might be the right answer, but it will change what it costs to get there necessarily. And so I think when you look at historical examples, I mean, the one that springs to mind for me is prohibition, right? Alcohol, and trying to control people's use of alcohol, and then repealing, the constitutional amendment. I mean, that was an attempt to control people's behavior. It was rejected. It was driven underground. It created lots of problems, and eventually it was recognized that it's better to keep it legal but regulate it in certain ways, or at least establish markets where norms are incorporated into the market. I'm not saying that is the solution here, but I'm saying it teaches a lesson where social norms can, in some situations, be a powerful force that's to be reckoned with. And if you try and go against them, the costs of certain solutions are very, very high. That would be the only piece I would add to working towards an efficient solution.
I'd just like to add that William the Conqueror was not actually invited by the Saxons.
That's right.
It was a police action.
Right. I don't think we want to live in that country, right?
Yeah, right.
But it had next to nothing to do with the economic solution.
Yeah, I agree that there is certainly a sense of entitlement to music. I think the vast majority of people in this room would believe that they have a right to obtain music in the way that most suits their needs. So if it means downloading and getting it from a P2P service, then that's the way they should get it. And I think we face a tough battle changing people's perspective on that just because you can do it and you think you can do it anonymously, that you shouldn't in fact do it. And that's the battle that we're struggling with.
Why?
I don't think there is a singular solution to that, but go ahead.
But why is it? What's the problem? We still haven't answered that. If people are sharing music, right? And certainly we've seen lots of small record stores close. I mean, people have laid off songwriters and some record labels as a result of the impact on the business model. If distributors really are potentially no longer necessary, and like Larry Lessig would say, go the way of the dinosaur, what's wrong with this model?
It's
He's out of a job.
yeah, no, it's not.
and I feel for that. I mean, that's important. I'll admit, a little while ago, before I became a lawyer, I thought of, what a great business on Interstate 95 if I would sell CDs at the various rest stops along the way, right? And started talking to all sorts of people to try to get something like that going. And boy, I tell you, if I had one of those stands and had a little bit of success initially and then Napster came along, I'd be kicking and screaming and not going gently into that good night either. But given the cost, right, the number of lawsuits you all have filed, given the cost of telling people that they have to change technology to suit copyright,
what I don't understand is the presumption there that somehow it's more efficient to have music be free and divorced of copyright as it currently exists, and I challenge that premise.
Everyone has access and is not denied access to music versus...
Right, but how does that lead to more music or better music?
Well, to the extent that artists are compensated, more music gets created.
Right. And why is it that making it available on the P2P without giving any control to artists lead artists to think they want to make more music?
Well, there's a difference though between control and compensation. Those aren't the same things.
Yeah.
Right?
If I have no control, then and I decide under your system that I want to opt out, what's to prevent someone from saying, you've told the people who run that peer-to-peer system that you want to opt out, but people want to put it on. Students decide they want those files, so they're going to trade them anyway.
But Dean, what if magically, and again, I have problems with getting from here to there, but we can sort of, it's like, that's why I used to love teaching law school, because you could make up all sorts of interesting hypotheticals that never could ever happen in real life. But all of a sudden, there was this shift and there was this huge pool of money created by peer-to-peer. Let's not say exactly how it creates, but tens of billions of dollars created by this. And it all flowed to the artists and the people in the middle who developed the artists. Why should the artists necessarily have control? Again, we have the example of mechanical license. I'm not saying it's right to do, but just why is that model wrong? I mean, and the answer you gave before was, well, we're living with what we have. And I think that the challenge that I heard both from Judge Rader and Professor Lang was think a little bit creatively. I mean, what would be wrong with taking their control away if all of a sudden they got, you know, a tiny percentage of a very, very big number?
Well, I think that gets to the core of it, is the presumption that if you do that, you're going to have a much larger number. I don't see that occurring.
So you don't think people are fundamentally dishonest?
No, I think what will happen is there will be a challenge in, why should I pay if I can have, you'll set up this regime, which is radio, and then there will be Grokster.
No, I
will
disagree.
challenge that regime.
I disagree. I think
And people will simply gravitate to the new existing technology or software, or more appropriately service, where it's now free, where you don't have to pay that $5 a month, and where no one can opt out.
But again, there are so many examples of competition against free that's been hugely successful. Cable TV and satellite. You don't have to pay for your TV. 85% of the 111 million households pay big bucks. Now, why? Because they can make it better than free.
But you can't get it unless you subscribe to the service.
Well, no, but you can get over-the-air television for free. The digital television station with this wonderful high definition in every community are broadcasting beautiful high definition for free.
Right, and the cable industry they're suing people who are stealing their signals.
No. They're not suing people who are getting free over-the-air television from broadcasters, right?
Right.
But the problem
So why are 85% of the people opting out of the free system and paying?
But our battle is not with the free or the alternative. The battle is with entities who set up infringing services and who then contribute to continued infringement.
Well, they're all gone. They've all been put out of business.
Well,
That's not
I mean,
true.
Dean's right there. I mean, the problem is that, you know, HBO can compete with The Sopranos because that's not what NBC is offering. So if your choice is between Survivor or 6 Feet Under, you can make that
if
choice,
my choice
right?
is-
But if HBO loses the ability to control The Sopranos, now it's a very different story.
But if you also gave somebody the opportunity to get HBO for free or pay $5 to get it legitimately, what do you think they're going to do? They're going to take the
If
free
it's an
model.
even trade, absolutely. No, I agree. The challenge is whether you can turn customers who are now criminals into customers again. And I'm not suggesting I know all the answers, Dean. I'm just saying the approach of saying we can't compete with free, I think I've heard that too many times to buy it any longer. The question is, again, and there are advantages to DVDs over the internet because it takes a long time to download a movie, but they're competing very nicely because you can get all that for free if you want.
I think we can compete against free, and I think we can do so well. I think the problem of currently competing against free is that there isn't a regime or a paradigm under which free gets to operate, or the paradigm that currently exists, they're not operating within those rules, and so it makes it virtually impossible for us. Let's say I decide to compete with free by making it better. So I put out an enhanced CD that has not only the songs, but has the video associated with it, and outtakes, interviews with the artists. And I try to sell that in the store. I'm trying to make my product better, but it can't necessarily compete with free because you can take the outtakes. You can take the enhanced portion of the CD and put it on the internet.
But you've succeeded there. Music videos are setting all-time records. DVD music videos are setting all-time records. The creative issue I never hear.
That's just a broadband issue.
What?
It's not,
I
it's not
agree.
a
No,
cultural issue.
I agree. But the question is, can you take advantage of the technology? See, I don't see a focus on saying, let's rebuild Napster, which has fundamental advantages over Grokster and the Kazaa, the Xiaoming network system. Let's see if we can connect people and artists better, offer something you can't possibly get on a peer-to-peer service.
agree.
Make sure people get virus-free stuff. The problem why you can't compete with free is you can't offer everything. That's the real nub of the problem, and that's the legal system. That's, to me, the issue. And I don't have an answer to solve that, and so mea culpa. But I think, to me, that's the issue, is how do we get people in there? I don't want, there's a lot of questions, so Dean and I could probably go at this all day.
Oh, I'm sorry. Since you had asked the question already, I was, yeah.
I have two questions for the panel. And the first one, I wanted to shift a little bit from the conversation about the economic stakes to, if anyone's interested in talking about the political stakes. I'm wondering where, or if, for any of you, in the arguments that you put forth, if you are thinking about or thinking this in relation to the massive consolidation of the media industry that has occurred over the last 20 years, and the threat to the health of our democracy that many people feel that is. That's one question. And the other question I have is about the sort of regnant concepts of copyright and intellectual property that are involved. Do you think that as they are formulated in these conversations, that they adequately reflect the paradigm shift that is the move from analog to digital forms of communication?
All right. So the first one being politically, what are we thinking about, especially given concerns about media consolidation? Given that your organization is supposed to defend digital liberties, do you have a take on this?
Yeah, I mean, media consolidation is a big issue, but I mean, I think fundamentally the internet has primarily served a sort of decentralizing purpose. I mean, I think going back to my answer about the sampling, I think if you move forward by supporting the users as a piece of the economy, right, which is that they're the ones who are going to be giving up some of their resources to help create the network by distributing and allowing people to find what they want. You also give them power to open up those resources to everyone, right? Media consolidation is very much about who has the access to resources, who can broadcast, who can put something on cable, who can put something in a newspaper, right? The more the access to resources, who controls those, the more that is decentralized, the more opportunities smaller and more alternative voices will have. So I do think that you're going to see, you already are seeing more efforts to have independent artists and other voices on peer-to-peer, and I think that's only going to increase. And I think once some of the legal uncertainty is resolved as the peer-to-peer, and if we can't work out a system where the economic uncertainties are resolved, that will just flourish. So generally, I would say it's probably along the right path.
I think you raised an important question, because one of the things that's often lost in this debate are the costs associated with file sharing. And for the purposes of the Constitution and promoting the progress of science and the useful arts, I don't think the use of the file sharing systems as they currently exist is useful. I was just yesterday at one of our members' companies, and they've laid off 20% of their workforce and are cutting 50 artists from their roster because they're having difficulty competing with free. I think within the next year, rather than having 5 major music companies, you'll have 3. I don't think that's necessarily the best thing for the development of artists and getting more music out there. I think there are tangible and real costs to what's going on today, and it's coming up with a solution is difficult.
But Dean, if I could there's an important distinction there, which is, the company, the record company may be laying people off and cutting artists, but the question is, are artists actually making less music? And I have yet to actually meet an artist who says, I was thinking about writing a song and I didn't write it because of peer-to-peer. I was thinking about recording a song and I didn't do it because I thought file sharing. There are artists who hate that. They hate the fact that their music's on it. But I'm really interested if there's any empirical data about artists actually not creating, not so much artists being signed or not signed, but the creative process and whether that's being affected directly, that's kind of what's underneath it all. And that goes to the constitutional purpose.
And I think you want to be very, very careful about throwing around these numbers and statistics and attributing causes. Because one of the things that, there's all this little underground stuff that isn't so underground. There are artists who are making lots of money recording music on media that's not sold by the recording labels. And it's called games. It's a huge, huge market. One of the things I love doing is going to music symposiums and being the odd guy out and speaking, not because I like speaking there, but I learn a lot about their business. And the business is in a shift that has little to do with peer-to-peer. I'm not saying peer-to-peer is good. It isn't hurting the labels. Don't misunderstand me. But there's a lot of other things going on with respect to the target audience that the CD was aimed at, the 12 to 22-year-olds, which means most of you, or even law students, are out of the target audience. And games is a big one. Cell phones, $1 billion worth of ringtones, DVDs. So there's a lot of sucking sound away from CDs. Now, again, I don't think peer-to-peer helps at all currently because they're not able to exploit it. But we want to be very careful about, assigning this issue because I don't think we all know the precise answers. We can only tell you a lot of anecdotal stuff. So it's kind of hard to tell what's going on out there with the encouragement to create music.
And I think going back to your consolidation question, we have to be careful. I mean, Dean might be right. It might be that we'll lead to fewer record labels if we leave this unregulated, but we might actually get to 0 record labels. And as long as music creation's not altered in the process, that wouldn't necessarily be a bad thing. And the concerns about consolidation would in many respects be a little more alleviated. And we have to be careful because Dean in his earlier presentation said, well, copyright or peer-to-peer is a subsidy of basically two peer-to-peer users. And if we go back to the early copyright laws and Macaulay and the debates on copyright in England, the idea was, well, no, in fact, it was the opposite way. Copyright was a subsidy, it was a tax for publishers. And we should remember, too, that it started not by the Statute of Anne, which actually did some very valuable things, but as a result of the Licensing Act, in which the Crown decided it wanted to give to a certain set of stationers the ability to control this new disruptive technology called the printing press. And in the process, they gave a monopoly and allowed them to control an industry and a technology that they had no hand in the creation or the deployment of, at the same time allowed for tremendous censorship, right? And so we have to be careful when we're talking about this for that concern and to go to some respects.
The second question, do you think that the current dynamic and the current laws are adequate for dealing with the issues that we confront? It's my view that we don't need new laws, and we don't need. I think the existing laws are adequate to deal with the challenge that we face. I think Sony struck the right balance. I think it's how we now interpret that. Is if you say Sony, then it gives you freedom to do anything you want as it relates to technology. I think the challenge is not technology. I think technology is a solution. It's what individuals and companies are doing with that technology that's problematic.
And that goes back to Professor Lang's earlier question to me, which was, do I believe that what the file sharers are doing is wrong? That's the problem. I mean, it's how you interpret Sony. How do you interpret Article 1, Section 8 to promote the progress and secure rights to authors? If that includes securing rights to distributors when it doesn't benefit authors, then we can interpret all these rules and rights broadly and prohibit file sharing. If we say no, more is needed, right? Sony and copyright has never really been applied to private copying. I mean, that was the fundamental debate that Sony kind of ducked in the end through the fair use inquiry. And it's not clear at all that Congress, when it stepped into the fray in the 76 Act, really meant to extend it to all forms of private, non-commercial copying. The problem is, where do we go? Do courts make that call? And while we litigate these cases, have the courts decide these fundamental issues that will affect the economy and innovation? Or is this one that goes back to Congress and ultimately to the popular sovereign in our country and the Constitution?
All of the above.
Yeah.
Well, the laws need to be clarified as well. If you look at the DMCA, you have this middleman who's called the ISP, that you don't have direct access to the individual who's infringing. You have no way to contact them. I know the RIAA got into a little bit of trouble when they sent some instant messengers through one of the networks trying to communicate directly. But the ISP is acting as a barrier to make direct contact with the infringer. And again, there's certain parts of the DMCA need to be addressed.
Yeah, the trouble is there are a lot of people who would want to go the other way with the DMCA.
Yeah, exactly.
I mean, it's nice to throw things, off from the courts, because the courts, are just a couple individuals making decisions. But going back to some similes, there's two ancient quotes that I like with respect to Congress. First of all, be careful what you ask for, you may get it, which is Congress's intervention, because if you like to eat sausage or respect the law, don't watch either being made. I mean, this is to me, I was deeply involved with the DMCA, particularly Section 1201, and I have to tell you, I'm still to this day not sure what that means. Yeah. And it's clear when you look at courts, and there was a huge argument with the section I wasn't much involved with, Section 512, as to what that means.
Well, Kerry was involved in drafting it, and I'm not sure he knows what it
Right,
means.
and Carrie and I had a big argument about what the Audio Home Recording Act meant at the time. So I mean, the Congress isn't necessarily the panacea, and again, my plea has been now for a long time, can we work it out in the business arena? I mean, I applaud EFF for throwing something out there. Well, I might have some problems, I know Dean has problems with it, but I think that we need to be thinking more along, can we work within the existing laws? Because it is very hard to change the laws, and the problem with changing the laws is that there's a group of people who really aren't there, which is generally the public, even though they elect the officials, and future innovators and future artists aren't there either. They can't be, because they're not identified. So it's a difficult thing to say, for me to say, let's just go to Congress, because it is kind of an unmanageable system.
But is it better to leave that decision to the courts?
Well, if
the best of the worst
well,
case
look,
scenario,
everything could happen, because I mean, the Sony case is an interesting example, which would be that could be a whole hour's discussion on that, because the court specifically in Sony said, well, people weren't archiving.
Right, exactly.
Now people are archiving now. So that means Sony doesn't work any longer? Or would a court say, well, that was then and this is now? Because DVD, recordable technology, does that change all that? Some of your sister and brethren in the motion picture industry have argued that it's changed Sony. So it's complex. It's not simple. Right?
Sticking with Sony was a fair use case, and one, I don't think I've heard anyone say, Professor Lang, even say the words fair use, and two, the anti-circumvention aspects of the DMCA kind of allow content owners to essentially circumvent fair use in that you can cover content with something that says, oh, you can use it, but nah, you really. Between the fact that fair use can effectively be cut out and thus Sony cut out, by sticking with it, and the fact that going back to Judge Rader's point, here, that for people my age, and I'm just ever so slightly older than the 12 to 22 demographic, and I've never seen a work pass in the public domain in my life. Between those two facts, that you've never seen perfect time. Between the fact that I've never seen something pass in the public domain, and there's potential now for everything I got with Sony when I was young to understand it, could be taken away with the wave of encryption program. Where does what do you say about that? Specifically,
yeah, but I want to answer the factual question, because I don't like the DMCA for a lot of reasons. I'm not a fan of it. I was involved. I have to take some minor responsibility for it. But your factual premise is not correct. All that encryption does is assuming you don't get a hold of DECSS or one of those programs, assuming that you act legitimately, all it means is you can't make a direct digital copy of that. You can, through the analog outputs, put it right back in the computer and get almost as good a digital unprotected copy. And if you use that copy, you're not circumventing anything doing that. You can use that copy.
But you can't circumvent to do it.
No, you don't have to circumvent to do it.
You don't
Absolutely
have to.
not. You just take if you've got a good YRPRB output, you simply take that, put it on a video capture card, and you've got a perfect, almost perfect, for your eyes, you won't notice it, a digital copy. And the Second Circuit recognizes this.
All right,
it doesn't
having read the
prevent
Second Circuit,
You disagree.
and then tried to use a clip from a DVD for an introductory class.
Yes.
I am fairly technologically savvy, was a computer programmer at one point, had no way to take that DVD, even through the analog outputs, and record it onto a videotape in any form. The closest thing I could do was take my camcorder and aim it at the television set. And then obviously no one likes doing that.
I hate getting into the technical argument, but you didn't have an NTSC output from your computer. I mean, mine has one. You just plug this right into a VHS, and you got it. So that's not very technical. I'm not arguing for the DMCA. Well, he's a Mac user. Oh, I forgot. Okay, no.
No, but part of the problem too, and I agree with you, the DMCA is fundamentally a bad example of legislation, because arguably in many respects what Congress tried to do was satisfy everybody. And it did it in a way.
That's all legislation.
Right.
Yeah.
Well, they did it in a way to muddy the issue, right? So you have 1201C. We're not intending to change anything about copyright infringement and fair use, but the implications of 1201A and B are clearly, well, maybe we can. And by kind of taking that middle road, muddy approach, they kicked the issue to the courts and kind of disclaimed any real responsibility for what's going on. And that's one of the reasons why we're in the conundrum we are. And so, to use other kind of political theory, if you really care about reinforcing deliberation and representation, you would probably want to adopt a rule that would require Congress to clarify what that position is, rather than having that issue resolved by the courts.
I agree to the extent that this sort of analog option does remain available in some circumstances, but the DMCA pretty much gets rid of digital fair use, I think, in many, many ways, in terms of keeping it purely digital. I also think, though, that,
Why is that necessary? If it's fair use?
I think fair use is something that should always be, in other words...
Fair use is intended to protect the First Amendment
as
it relates to the Copyright Act.
I think it's a lot broader than that. And I also think that we used to, have this idea that, the users get to enjoy fair use to the extent that, in other words, if it would still have been a fair use, the users get to decide to do that. That shouldn't be taken away from them. It's only when it falls into copyright infringement that they no longer have that choice of what they want to do with it and how they want, whether they want it digital or analog or anything like that. And I think the DMCA takes that away from them. I think it takes away that choice. I also wanted to point out that there is an effort to take away a lot of the analog fair use opportunities with the analog reconversion efforts. Because right now you are dependent on what ports and plugs are in your computer or in your devices. And you think, oh, well, there'll always be lots of options. That's not true. There's a lot of negotiation for regulation from the FCC, for regulation and laws from the government, and to take away the opportunity to use analog for fair use. There are efforts to say that you can't, if you do make a VHS copy of something on the TV that was digital, that you can't then convert it to digital. You can't go from the VHS copy back to digital. And a lot of these efforts are being fought right now in Congress. It's a lot of topic, but there is something at stake there for analog fair use as well. It's not necessarily going to be guaranteed.
Just so I have a better understanding of the baseline, why would you want to copy from a perfectly digital copy, as opposed to just playing the DVD you have?
Because I might want to show it in class.
And how are you disrupted by taking the DVD and showing it in class?
Well, maybe I want to make a composite. Maybe I want to do a review of several different screenshots from 14
why do you need
DVDs.
Why do you need a digital version? Why is the analog version not good enough?
Why does anybody want digital instead of analog in the world? Because it's an option to have better quality. You can do more with it. You can manipulate it. You can put text over it. You could put it in context by comparing and contrast it with something else. The digital world, is pretty amazing, right? You can be much more creative in a digital world than you can in an analog world as a creator yourself. If I want to put together, collage, it's much easier to do with digital images than to take analog images and try and piece them together.
On that, I think we're out of time, and we were left with the question of who decides, right? The copyright owner or the user. Thank you very much.
Thank you all.
Thank you.
All right, just a couple of quick announcements. Lunch is ready now. It's in the Bourbon Lounge. We'll have some people pointing, but you just go all the way to the back of the school, go through the door. We'll have people there going for you. Also, this is all webcast, actually, as are the talks that are going to go on this afternoon. And so if you go to our website, you can click and you can get our webcast there. Or later on, I'm sure someone will put it on some file sharing network, so you can put it on there soon.